basically conduct your day-to-day lives as practitioners, working with experts and working in what is a difficult field. We'll bring you up to date on the latest Australian cases that are basically evolutions or interpretations of Makita. So we won't be using authorities for the sake of it, or here's a case that was delivered last week, it's really good fun, and hitting you with that. It's more, again, we're going back to fundamentals. And in my part of it, which is the third part, offshore, two UK authorities which you need to know about, both of which are very useful here under certain circumstances, and frankly, because I think Canada is overlooked, a very short exposition on a Canadian case. So that's the roadmap for this afternoon, and I'll hand over to Julie.
Thank you. And for anyone who's lucky enough to be here on Tuesday as well, you're either really keen to see me again or you're absolutely desperate for CPD points, so I'm going to assume it's the former. So just as Tony said, going back to the beginning, and before we look at some cases, just a bit of a reminder of the Evidence Act and some basic requirements, and really what are we all here for and what is expert evidence all about. So everybody will know that we start with the opinion rule, and the starting point with the opinion rule is that opinion evidence is not admissible, and that is why we need to go to an awful lot of trouble to deal with expert evidence properly, because if we don't, we will be stuck with 76, opinion rule is not admissible. So we need to make sure that we're falling in the exception, which is in section 79, and that requires both specialised knowledge on the part of the expert and an opinion which is wholly or substantially based on that knowledge. So let's just break that down a little bit. Specialised knowledge. So the expert has got to be giving evidence in a recognised field that is expert evidence. So you can't necessarily be an expert in things that the court doesn't recognise is expert evidence. So in Hyde State of New South Wales, that was a case that involved a claim for wrongful arrest, false imprisonment and malicious prosecution. And the plaintiff sought to leave some evidence from a retired detective chief inspector to the effect that there was no probable cause to arrest and charge the plaintiff. And the court said, well, that's very interesting, thank you, but that's our job to find out whether or not there was any probable cause. That is not a matter of expert opinion, that is a matter of the law, and that's for us, thanks. So pretty... might seem like a harsh decision, but we've got to be careful. The court likes nothing more than bashing people who try to tell it what the law is. So that was not a specialised, recognised expert field. It's got to be based on their study, training or experience. So what is the expertise of your expert when you're considering briefing someone? What is their study? What is their training? What is their experience? They don't necessarily have to have all three, but they need to have at least one of those things that they're basing their expertise claim on. Have a good look at their CV. What an expert tells you he's an expert in doesn't necessarily mean he's actually an expert in. Has he got anything in his CV to back that up? Has he actually got any real-world experience to back that up? Beware the expert who's only an academic expert. Most of those don't go ever so well up against people who are both academic and experienced experts. And make sure, I'm in construction, I find this with engineers a lot, your engineer will be an engineer in a specific area like a geotech or a hydraulic or whatever it is. Your geotech engineer might think he can respond to the report of the other side that's from a hydraulic engineer, but he can't. Okay, so try not to let your experts be an expert in all matters in which they are, in fact, not experts. And no engineer, bless them, can tell us what the contract means. Okay, that is a matter for law, it's a matter for submissions, they all do it. They all do it. Engineers' reports are full of contract interpretation. It's no good, get it out. Opinions outside the area of expertise will be struck out, and that's the Menz and Wagga Wagga case. The opinion must also be based on the specialist knowledge. So even if you've jumped the hurdle that you've got an expert, and even if they've got specialist knowledge, this is the bit that really bites in the report. They've got to show that their opinion is based on the specialised knowledge, and that requires an exposition of their reasoning. I spoke about this Rodriguez case on the last time that we were here. This involves some evidence concerning the failure in 2011 of the Somerset Dam, and the expert was, of course, called Mr. Dan. All sorts of dam problems with the dam transcript, one imagines. Now, an objection was taken to Mr. Dan's opinion, which was on what obligations were imposed on the flood engineers of the Somerset Dam by a document called a flood mitigation manual. And the judge said, to give evidence on that topic, i.e. what the manual means, it must be demonstrated that Mr. Dan had a specialised knowledge based on his training, study or experience, and that the opinions he expresses are wholly and substantially based on that knowledge. It might be that a civil engineer in Mr. Dan's position is capable of bringing expertise to bear on the determination of what the manual required, but in the absence of any substantive reasoning, and that's the catch, in Mr. Dan's report to support the above conclusions, that left me unsatisfied that the conclusions he expressed were wholly and substantially based on that knowledge. So he was an engineer who didn't try and tell the judge what the law was. He tried to tell the judge how you apply a particular document. And the judge said, there might be an expertise in that. I might need a civil engineer to help me with that. I might recognise that a civil engineer has expertise in how that document works. But this one hasn't told me how his expertise can do that. Now, moving on to the UCPR, of course, for those of us in the Supreme Court, happy days, we've got to deal with UCPR Schedule 7, and some of you will be as old as me and you will remember the old days when it used to be called Schedule K. Most of us are pretty familiar with what that says. It sets out the basic content requirements for an expert report. The expert must acknowledge the code of conduct, agree to be bound by it, and so on, set out their assumptions and facts, examinations and tests, reliance on others, limits on qualifications, and a brief summary. Now, here's a top tip. The summary should be A, brief, and B, a summary. I recently sold a report where the summary was almost exactly as long as the whole report. So it really, and it was very, very detailed, so it failed both hurdles. And that's a really, as a practical matter, there will be many people, including some people who sit on the bench, who don't get any further than the executive summary. So it needs to be short, it needs to be punchy, and it needs to say why you should win and why they should lose. So a really good executive summary is a great start to any expert report. And I don't know about Tony and Adele, but I'm well and truly of the view that as lawyers who are presenting evidence to the court, it's entirely a matter for us to make sure that that evidence is coherent. Engineers, I hope there's none here, cannot draft to save themselves, and so you need to slash and burn their reports to make them intelligible. And if that means writing a pithy summary as well, you can do that. As long as you're not changing their opinion or in any way interfering with their independence, you can edit their reports. I think not only can you, you should, because the thing that you're first given, as we all know, is nowhere close to what it needs to look like. And finally, just the independence point. Like I said, you can't change their opinion, obviously. Finally, the federal court. Now, again, we covered this in a talk either last year or the year before, when the federal court produced its new and exciting practice note on expert evidence, and it really is far more prescriptive than our current Schedule 7. And you may think, why do I care about that? I'm never in the federal court. Well, it'll come to us. We will eventually get that whole extra detail trickled down to the Supreme Court. You can bet your life on it. It is a large, weighty tome that consists of a note to all of us, a code of conduct for the expert, and some concurrent evidence guidelines. The federal court, like the Supreme Court, is pretty keen on concurrent evidence, and because it's all still a bit of a mystery to some people, the guidelines are pretty useful in telling parties and experts what the court expects when experts are giving concurrent evidence. The code is similar to the UCPR, so an expert wouldn't be surprised by reading the Code of Conduct. There's nothing in there that they wouldn't ordinarily be signing up to. The note, however, which is the one that's for all of us lowly practitioners, is quite the read, because it is very, very prescriptive, and it contains some very clear warnings to us on what we can and can't do in the federal court. The expert is not to be a hired gun. That's the phrase used, not to be a hired gun. Parties are not to have inappropriate communications with the experts. I don't know what that is, but I'm sure somebody can find out. I assume that means you can't ask them out for dinner. I don't know. And the court does not encourage the practice of dirty experts. And the way you read this is you can be punished with costs if you have a dirty expert. So if you've got a big claim where you have put on your expert, but frankly you need somebody to tell you what your expert evidence really means because it's really complicated, and how to cross-examine the person on the other side, your expert can't really help you with that because they've got to maintain their independence, but your dirty expert can. And lots of people hire dirty experts to assist them with forensic decisions and cross-examination and so on. The practice note warns against that, says the court doesn't like it. And so, the cost consequences of that will be that if you have one and the court works it out, or later on even if you're having a dispute about costs, the costs of that dirty expert are going to not be recoverable. So I think that's a real problem for the federal court, or for us who practice in the federal court, because that's really overreaching by the judiciary. It's telling us what forensic decisions we can and can't make about how we run our cases. So that's pretty nasty, but it's there, and we're going to have to deal with it somehow. The note also directs the parties to read the note together with the Federal Court of Australia Act, and in particular the overarching purpose. And we'll all remember that the overarching purpose of the civil practice and procedure provisions is to facilitate the just resolution of disputes according to law and as quickly, inexpensively and efficiently as possible. So just beware of that, because the way that it works with the note is that it might translate into cost orders. If the federal court can look at the way you've conducted a case and say that is not consistent with the overarching purpose, they may be inclined to prevent the recovery of some costs. So I guess the moral of the story is only go to the federal court if you really, really have to, for the time being, but one day this will trickle down to the Supreme Court, so we better watch out. Right, I'll hand you over to Adele.
As Julie said, the starting point is always the Evidence Act, section 76 and 79. But the starting case law, as Tony said, is Makita. This is one relevant paragraph. I will read out some other principles. Put them as a screensaver, have them in your bottom drawer for when you're preparing the next expert report. As you know, that Makita was handed down by Justice Hayden, as he then was, and he set out 4 relevant principles. The first, it must be agreed or demonstrated that there is a field of specialised knowledge. The second, there must be an identified aspect of that field in which the witness demonstrates that by reason of specialised training, study or experience, he or she has become an expert. The third, the opinion expressed must be wholly or substantially based on the expert knowledge of the witness. And the last principle, for admissibility, the evidence must explain how the field of specialised knowledge in which the witness is expert by reason of training, study or experience, picking up the language in the Act, and on which the opinion is wholly or substantially based, applies to the facts which are assumed or observed so as to produce the opinion which is propounded. The first case that I'd like to speak to is a recent Court of Appeal case. It was handed down at the end of last year, and indeed our new president coming in for the Court of Appeal represented the Commonwealth. But I also want to take back to a 2016 case which relates to the admissibility of particular evidence. These proceedings unfortunately concerned tragic circumstances. It involved a wreckage from a vessel that travelled from Indonesia to Australia in 2010. There are a number of deaths, and the people who were on the boat, along with some observers and the people who died, their family, were the plaintiffs in this case. They sued the Commonwealth to say that the Commonwealth owed a duty to collect the wreckage and to save these people. Unfortunately, some people died, and the plaintiffs sought damages for the alleged negligence. The proceedings were originally heard before Justice Bellew, and there are a number of interlocutory applications, and one of them concerned some expert evidence. Once the proceedings were finished, it then went up to the Court of Appeal. There were a variety of grounds of appeal, and one of them concerned the admissibility of an expert report of Mr. Pike, who was retained by the plaintiffs. Mr. Pike had authored various books about boats. He had also had taught a number of lifeguards and also state guards in the US, Australia and Singapore. What Mr. Pike was asked to do was to look at the towage line between vessels and whether the Commonwealth, with the vessels that they used at the time and then went to the wreckage, could have pulled the boat that had crashed. When looking at these cases and coming from a maritime family, I unfortunately couldn't understand all of the terms that were used and indeed all of the formula. So I thought it might be easier to use pictures to be able to describe what Mr. Pike was asked to do. Essentially, what the boats that were at the wreckage and that the Commonwealth had around Christmas Island were the ones on the right. They're referred to as rigid inflatable boats. What, however, Mr. Pike used the formula for was actually what we see, and indeed what my dad used to sail as a tugboat master, which is the reason why I used the picture on the left, is a traditional tugboat. Indeed, one is used just to sort of carry people around, as you can see, with the number of people. The other one is to pull in and out merchant vessels, clearly has different power. Before though, I want to talk about the formula that was used and the Court of Appeal spoke about. I just want to draw attention to one of the criticisms that was levied at Mr. Pike by Justice Bellew, and it related to, again, his knowledge and experience and the way that he applied that, again going back to the Makita principles. The relevant part of the report, Mr. Pike opined, I have had access to the comprehensive weather report produced by the Bureau of Meteorology covering the period of the incident. It would appear that the wind had only recently switched around to a northwest direction. The waves are unlikely to have reached full maturity, and from the wind evidence and that seen on the various video evidence of the rescue, I would estimate the average wave height to be 2.5 metres in the open seas. Where the reflected waves interacted with the incoming waves, the sea conditions were considerably rougher. I have no idea what that means. That wasn't a criticism, though, of Justice Bellew. What he did say was in relation to his knowledge and expertise and the way that he set out his opinion. Justice Bellew noted, first, while Mr. Pike may have published a book titled Powerboats in Rough Seas, and whilst he may have also had experience in what Mr. Pike described as rough weather evaluation, Mr. Pike has no relevant training, study and experience which enables him to express opinions as to matters such as wind speed and wave height. Second, reading a report and being the Bureau of Meteorology report does not involve the application of any specialised knowledge based upon his training, study or experience. And third, even if Mr. Pike was appropriately qualified to talk about and opine on weather conditions, the opinions expressed do not expose any reasoning process which was adopted in forming such opinions. In particular, he has not explained why it appeared the wind was blowing in a particular direction and the basis of his estimate of the wave height. As I mentioned, the Court of Appeal only focused on the formula that was struck out by Justice Bellew. There were various parts of his report that had been struck out, and indeed the Court of Appeal noted that the plaintiffs did not seek, after those parts had been struck out, to then file a supplementary report. Relevantly, the Court of Appeal said that Mr. Pike did have relevant expertise and to this area. What he didn't do was set out in relation to the formula for the tugs as opposed to the other rigid inflatable vessels, the critical integers to his calculation, and indeed you can see that there's considerable differences between using a comparison of the two vessels, one that was at Christmas Island and clearly the other one was not. The next case it relates to easements, and again, it relates to supplementary reports that are filed by experts if and once a trial judge rules that an expert report is inadmissible. These proceedings were before the expedition list at the end of last year, and as I mentioned, relate to an easement over 2 neighbouring properties in regional New South Wales. The critical issue was an easement going over a riverbed and water heights. In assessing these easements, there are a number of options that were put by the parties to Justice Saka, and the plaintiff relied on an expert opinion by Mr. Buscher, who was a civil engineer, a hydrologist, and a flood risk specialist. And indeed, Julie did point out, the difficulties and sometimes the concerns of reports by engineers, and this is a good example. Objection was taken by the defendants on the basis of Mr. Buscher's report that he'd failed to explain the connection between his specialised knowledge and the facts assumed and his ultimate opinions. The difficulty that he had was that he decided to go and speak with 3 other people not related to the case, one of whom was a government official, another who was a consultant, whom his solicitors did not ask him to consult with. Justice Saka noted that, and it was indeed set out in Mr. Buscher's report, that he had spoken to these 3 people, but Justice Saka couldn't understand why. And Justice Saka said, "It was explained to me, at least on the face of the report, that some of the views expressed by some or all of these people, being the 3 people who he'd interacted with, may have somehow impacted upon Mr. Buscher's ultimate views. That is not what he is here to do. His obligation under the relevant code of conduct is to provide material to the court in a transparent fashion, but that does not permit him to talk to bystanders along the way who may or may not be true experts in their own right and just pick up a view expressed by them and retell it to the court, even if he agrees with them. This is not a display of expertise on his part. That simply seems to me to be an exercise in fortifying his opinions by the use of other people whose opinions he may well respect, but who have nothing to do with water analysis or risk analysis associated with water." As I mentioned before, His Honour Saka did not strike out the report, but did give the plaintiffs an opportunity to file a supplementary report. And indeed, the plaintiffs took this opportunity and filed 2 further supplementary expert reports. But indeed, as so many of these cases go, the second tranche of expert reports were also criticised. Justice Saka said about these supplementary reports, "Experts usually should provide their expert opinions given a set of factual assumptions provided to them, which the calling party is obliged to prove. It is not appropriate, especially if uninvited, for experts to engage in their own sleuthing or investigations. There are obvious dangers with this course of independent investigation, principally because the expert is uncontrolled and may be influenced by inadmissible or untested evidence. It is imperative that in their letter of retainer and during conferences, solicitors keep in mind the necessity of keeping control over expert witnesses. Experts may, as they have done in this case, attend a physical location or inspect a physical object. In this sense, the expert introduces their own factual material, such as measurements or readings in respect to which they may ultimately express an opinion. Experts may also refer to learned journals as well with respect to fellow scientists. However, it is imperative that an expert should set out the detail in what was observed, read or undertaken as to what their opinions are based on their expert knowledge. Now, indeed, Justice Saka didn't go into details as to how to control your expert, but indeed it's implicit there that you must know the facts and the materials that your expert use, otherwise this would then become a means or indeed fodder for the other side to cross-examine your expert. The last case is something, and I'm sure that a lot of you are familiar with, is Mr. Rush's case against the Daily Telegraph and Nation News, and there was a second respondent. It related to two front-page articles that were posted in late 2017, which Mr. Rush alleges were defamatory. The articles and poster alleged that an actress had made a complaint of Mr. Rush of inappropriate behaviour during a stage production of King Lear back in 2015 and 16. As I'm sure you all know, Mr. Rush denies the allegations, and we're still waiting for judgment by Justice Wigney. One of the allegations in the proceedings was that these publications damaged Mr. Rush's reputation such that he is now not received, and in the foreseeable future is unlikely to receive the same number of offers of work as an actor as he had historically received. In support of this claim, Mr. Rush sought two expert opinions in relation to the economic loss. These experts were also engaged to respond to an expert report that had been served by the respondents, which related to a LA attorney who said that if Mr. Rush's career, if he was vindicated, that he would not suffer any economic loss. The two experts who Mr. Rush retained are actually personally known to Mr. Rush. The first is a screenwriter, producer and director. His name is Mr. Shepesi. He worked with Mr. Rush since 2011 in apparently his movie The Eye of the Storm, and is known to both Mr. Rush personally and his wife. The second expert who was retained was Mr. Spector, and Mr. Spector's been in the industry for over 60 years and has been Mr. Rush's agent for over 20 years. So it comes as no surprise that the respondent said that these two experts were not independent. There were three bases for this. One was based on the assertion that both experts were not necessarily capable of being impartial. The second basis was that both experts had obtained information relevant to the formation of their respective opinions in the course of their relationship with Mr. Rush, which was not part of the identified body of information to which the expert is authorised to have regarding to preparing the report. And the third was in relation to prejudicial evidence. Essentially, what the objections rested on was independence because of their personal relationship, and also because it was not understood which part of the body of the report referred to their personal knowledge or their expert knowledge within the entertainment industry. In support of those three objections, the respondents relied on particular parts of the federal court rules and also the code of conduct, all of which, as Julie pointed out before, relate to the independence of an expert and their impartiality. Indeed, one of the clauses of the Code of Conduct says that the role of an expert witness is to provide relevant and impartial evidence in his or her area of expertise. An expert should never mislead the court or become an advocate for the cause of the party who has retained that expert. This was independence was something that was considered by the federal court, and those who attended this time last year may remember the case of Guy and the Crown Casino, where the applicant accused Crown Casino that the particular poker machines misled players. The applicant had retained an expert, Dr. Livingston, who is well known to have a dolphin poker machine in his office, and also an advocate for anti-pokies. There, in that case, it was found that Dr. Livingston was not independent, and indeed he hadn't signed or made a declaration in the report that he was independent and abide by the code of conduct. This was a different situation here, where both experts had signed and abide by the code of conduct. It was on this basis that Justice Wigney said that both experts would be impartial and would give evidence that would be of the benefit of the court. However, what Justice Wigney noted is that independence is not relevant to admissibility. Independence actually goes to weight. And it was here that His Honour emphasised the importance of Sections 76 and 79 of the Evidence Act. His Honour noted, Justice Wigney noted, that admissibility comes down to two things, as Julie pointed out earlier: that the witness has specialised knowledge derived from training, study or experience, and the opinion is expressed by the opinion expressed by the witness is wholly or substantially based on that specialised knowledge. His Honour noted that there is nothing in Section 79 that imposes an additional condition that the witnesses are independent, or that his or her opinion is demonstrably objective or impartial. His Honour then reiterated that it is not a precondition for a witness, but it is highly achievable and thought of that you need to have an expert who is independent. And that then leads to Tony and overseas cases.
Before I hit the overseas cases, just want to head off piste for a minute. Julie was talking about her experiences with engineering experts, and so I was just contemplating what is in ranking order, which expert conferences do I dread the most and which expert conferences do I dread the least. The conferences that I dread the least are inevitably meetings with expert architects. Inevitably. They're always quite enjoyable. The architects know how to write, they know how to express themselves. The only difficulty is their fundamentals are, let's say that sometimes the fundamentals get disguised behind beautiful writing and really good layout. At the other end of the spectrum, and so it's easy to actually get lulled, and although that's a trite thing to say, the reality is, in my experience, it's awfully easy to get lulled by an architect's report. They are often beautifully expressed. They are often very clever. They often read like a lot of my submissions, which is to say they're very pretty, but there's not a hell of a lot lurking beneath some of them. See this morning in Brisbane. At the other end of the spectrum, I think I have a two-way tie between delay experts and quantity surveyors. I think those are my big two. The difficulty is this: I really inevitably like the delay experts and quantity surveyors as people, and at Christmas parties I inevitably end up hanging out with them. But the difficulty is when they're in chambers or when you're in their offices trying to work your way through the gibberish that they produce. It is trying to have a delay expert explain what they have done with critical path. I've just learned over the years that it's just possible that it's not me. It's just possible that it's not me who is in fact the one who is completely stupid. It's just that I'm not quite understanding what they're up to. That's benefited. It took at least 15 years at the bar before I worked out that it possibly wasn't me. QSs, different category. QSs, I have an enormous, as I do with delay experts, but at a different, because it's a more academic discipline, QSs are, in my experience, the ones that I use tend to be tremendously overworked. A top flight QS, and there's one that I work with in Singapore who I think is truly sensational, but the way that I came across her is in a matter where she was the lead expert in a large arbitration, and it became abundantly clear that despite her superb presentation, her superb method, her seemingly superb method, and her fantastic floor presence that in fact she'd over-relied on her juniors. And of course, she hadn't properly disclosed the number of juniors who she'd relied on in the report, because the senior junior who she'd relied on hadn't actually done it. So it turned out to not be her fault that her report contained a fatal flaw, but it literally unravelled around her. And it was one of those rare cases where you think to yourself, yeah, that was kind of unfair what just happened then, because obviously an absolute U-Butte snorter of an expert. Knew her theory, knew her practice, just didn't know the facts of the case. Didn't know the facts upon which she had to opine. She'd relied, and then when a list of names was put to her, she said, I don't believe they worked on my report. And of course we had the emails sitting around, and we had the emails sitting on the desk waiting to put them to her. And then of course she had to admit by the end of it that really she didn't have sufficient knowledge of her own report. But the punchline is this. I'm sorry, I've been told not to go roaming like I normally do because there's a camera looking at me. The way that I've gotten round that, and there's another, there are, without naming names, there are 3 big QS firms in town. Provided the quantum of your dispute is big enough, I find that insisting that the lead expert actually does the work at their $1,200 an hour rate pays off in spades. Or alternatively, work very closely with 1 or 2 highly skilled seniors on $800 or $900 an hour. It ends up costing your client. Ironically, the costs don't end up playing out all that differently, because instead of having juniors working at $400 to $500 in triplicate, you end up with a much more solid report where the expert is in a position to say, I only relied upon 2 people, and this is the extent upon which that I relied on them. And look, the reality is we started this series a few years ago when the new schedule came out, after the justices all got together and decided that Schedule K wasn't really working, in the belief that everything was going to change in the field of expert evidence. The reality is, these years on, it hasn't, and things are fundamentally the same as they've always been. So it's probably time for another round of reform. It'll certainly liven these seminars up. But one area that it has changed in a very good way is, by God, if you do an expert report, if you're from KPMG, more on KPMG later, if you're from KPMG and you do an expert report, you'd better set out the names of juniors 6, 7 and 8 who actually worked on your report, and you'd better set out pretty damn carefully exactly what they did. If you do that and you do it properly, then you're going to have a fantastic report. If you don't do it and you don't do it properly, then again, advocacy is going to turn on you very, very quickly, and you're going to find yourself standing in a courtroom in a very isolated way, or worse still, you'll find yourself in a hot tub with a well-trained expert from my side pulling you to pieces, which is even better than when I do it. Having your own expert pull apart another expert in a hot tub is truly sensational. Like Julie, I belong to the school that says that we are in the business as professionals, as lawyers, of ensuring that experts deliver coherent evidence to the court in a linear and focused way. There is good authority in the last 2 years for that point, that we have an obligation as professionals to ensure that experts assist the court, comply with the overarching obligation, and the punchline is this: we can interpret that perfectly legitimately as we can get involved in the process, as long as the expert can stand there and say, the opinion is mine and not Mr. Dam Thomas's, the world is a perfectly happy place. Wright is interventionist, I'm interventionist, it works. But you do have to make sure that at all times it is their opinion. The moment you tell them what to say, when the emails come out, you're in a great deal of trouble. The cases. I've only got 3. One I've dealt with in a previous session, but it stood the test of time. The first case is Bank of Ireland and Watts. Bank of Ireland and Watts, at the time, when it first came out, looked like a cautionary tale. Look, it's matured with age, and it's still a fantastic decision to add to your basic armoury of cases to roll out when you need to on fundamental principles. It's got some really great fun, flashy quotes. It has all the hallmarks of a really good fun train wreck. But again, when you lurk behind it and read it properly, and not worry about whether it's going to amuse a crowd at a CLE, there is some really very good stuff there. The first point is when an expert isn't sufficiently independent. Now, you've heard a lot about independence today, and I'm not going to give you the basic principles again. But what this decision does at paragraph 59 is that it concludes that the bank expert was not a properly independent witness because he'd been working for the bank as an expert for some 20 years. Really, he only did their work. He worked for the bank as an expert for 20 years, and he really only did their work, and his company was dependent upon the bank's work. Now, it's a classic example of where when you're either engaging an expert or alternatively, when you're up against an expert, since this case came out and since I considered it properly, there's been one occasion when that has really paid off. The simple question, how much work do you do for company X, is a very powerful one. Similarly, when you're vetting an expert, because by God, our role is to partly vet our experts before they come to us, it's worthwhile asking the question, particularly and always when the expert is introduced to you as being, oh, Ms. X is the person that we want. Now, that's all well and good. Ms. X is probably fantastic, but just make sure that Ms. X doesn't fall into the what's category. Here's what the judge said. Poor old Mr. Vossier's close relationship with the bank was borne out by many things. His unrealistic approach to the allegations, his attempt to mislead the court, his application of the wrong test, his unreasonable intransigence which led to his refusal to make any concessions whatsoever, and the fact that many of his criticisms, which he did not withdraw, were so unpersuasive that the bank quite properly declined to even plead them as allegations of professional negligence. I deal very briefly with each of those matters in turn below. They support either separately or cumulatively my conclusion that Mr. Vossler was not an independent or reliable witness. Now, the second point is where the expert does more than is reasonably necessary. And again, this is what I missed on the first reading and the first presentation of this case. It's actually a gem of a point. What the judge did was the judge looked at what the two experts for each side, I'm roaming again, what the two experts on each side, what their briefs were, how wide their briefs were, and what their fees were, which turned out to be a fantastic inquiry because theoretically, expert X and expert Y, if they are opining on the exact same thing, realistically, there should be at least some concomitance between length of report and cost of fees. Now, sure, I know that when I bring KPMG into a matter, they're going to charge more than Quarter Mentha. I know there's some relativities out there. I know that when I use WD Partnership, they're going to be more than Tony Macon. But here, it was two reputable experts, one of whom charged in the particular case that really led the ship to sink. One expert charged £1,500 and produced a normal-sized report of a few pages, and poor old Mr. Vossier spent 24,000 quid, which led the judge to start talking throughout the judgment of a factor of 30, deficient to a factor of 30 over and over again. So 30 times more in the cost and also multiple volumes. So you've got the hired gun expert who only does work for the bank, who's charging the bank a fortune and is delivering far too much material. There's a relativities point here. We've dealt with it in a previous seminar about where there was a cautionary tale that came out of Victorian Supreme Court last year about be careful about the balance and imbalance of your experts or there'll be some cost consequences. This is an extreme example, but it's well worth bearing in mind. Watch your relativities. Next thing that came out of this one, which is really just plain old enjoyable, is there is no learnings from this. It's just fun. One of the major issues raised in Mr. Voss's expert report was his uncompromising view that Watts as the monitoring surveyors were obliged to start from scratch. There was a highly misleading quotation. The full passage reads, "When involved with smaller developments and inexperienced clients and contractors, the project manager, whilst strictly responsible to the client, may have also been asked to perform a hand-holding exercise with the client." Now, on the page there, you may be able to see it from here. Good luck on the streaming. There are some words in bold and there are some words in black. Unfortunately, when Mr. Vosser quoted them, he deleted all the words in bold, which changed the context somewhat, which gave the judge the ability to say, the passage which Mr. Vosser reportedly quoted in his report deliberately excised the words which would have shown that this part of the guidance was completely irrelevant to the facts of the case. So again, you've got left with two conclusions. Number one, that Mr. Vosser is a complete idiot. That's conclusion number one. And really, it's an available conclusion. Or alternatively, that Mr. Vosser is part of a very large machine that is in the expert witness industry. That Mr. Vosser's company is in the business of supplying reports to banks when credit is a problem, and that Mr. Vosser simply scrawls his name on the bottom of reports that contain errors of such catastrophic magnitude that they would bring the company down, as they duly did when they're discovered. So this one here, again, it's an interesting cautionary. This one ties back, even though it's fun, because, I mean, for God's sake, a deliberate misquote of another expert is an extraordinary thing to do. But it ties back to the make sure your expert is actually in control. Mr. Vosser also applied the wrong test. Make sure your expert applies the right test. I don't need to say anything more about that. Unreasonableness. Again, simply because it's fun. I consider Mr. Vosser does cop this one. It's not his juniors. Mr. Vosser's approach was thoroughly unreasonable. He made no concessions at the experts without prejudice meeting, using them instead quite deliberately to raise entirely new matters with his opposite number, Mr. Whitehead. Step number one, for God's sake, get your expert to make reasonable concessions where reasonable concessions have to be made. It looks good, it's the right thing to do, and there is always a concession to be made, and it actually survives the reasonableness test. I ask all of my experts to do it wherever possible. If it's sensible, for God's sake, do it. You won't impress me if you come out and say, I held the line, Tony. Don't hold the goddamn line. Do your job. He made no of his concessions in his oral evidence, although in his closing submissions, Mr. Mitchell accepted one. And there are various examples here of Mr. Vosser's unreasonableness. Listen, I'm not going to read them to you, but whenever you need an example of an expert being unreasonable, again, even though this decision is fun, it's actually got some practical application. If you can tie the conduct of an expert to this case and say that it is analogous, that it is a Vosser style of unreasonableness, a Vosser level of unreasonableness, then although it's cute, it's actually very effective. There is a reason why this case has been reported at the highest levels. There's a reason why this case made it all the way through to the very top of the UK tree, and there is a reason why this case is absolutely beloved in the way that Makita is absolutely beloved, because you can use it as one of your lodestars. You can literally look at the conduct here and you can say, well, it's not as unreasonable as Mr. Vosser, but it's well on the path. Or here's the test for unreasonableness. This is what Vosser did to be held unreasonable. The conduct of my expert is nothing like it, and the submission should be withdrawn. It's a very useful case because it's not extreme. It's not some unreported decision out of Timbuktu. It's at the highest level of the UK. Okay, that's case number one. Case number three, Canada, is going to take me about 20 seconds, mainly because it's just a fun little quote. How do I do this? Imperial Chemical Industries versus Merritt and Merritt Merrill. There are two of these. There's a 2017 decision. Well worth, again, the 2017 decision is on the liability side of the case. Split trial, cautionary tale about splitting your trials, but that's not why we're here today. I've dealt with the liability side in a previous seminar. Again, it's a whole lot of fun, complete train wreck. On a more mature approach to it, again, very useful indicative examples of where experts go horribly wrong, but also some very good useful indicative examples of where experts go horribly right. What does a good expert do? And I know it's a whole lot more fun in these seminars to focus on what a bad expert does, but it's almost more instructive when a court says, expert X was good because. and it's inevitably only one paragraph, and you can use it in the same way as your VOSA. You can say, rather like Mr. X or Ms. X in Merritt Merrill, this is what my expert has done. My expert has made sensible concessions. My expert has properly set out all their assumptions. My expert has made drawn no conclusions whatsoever from facts they've relied entirely upon what they're instructed to do. This is a quantum expert case. So, liability. Case goes completely haywire. One side loses out big time. Vast criticisms of the accountants who've been involved in the liability side. We move on to quantum. Same accountants continue through from liability to quantum. So the same expert who got slammed on liability continued through to quantum. There is a lesson for our times. If your expert gets slammed in the liability side, do not bring them through to quantum, even though they may be from Grant Thornton, as the expert was in this case. Just don't do it. You can see how it would have worked. Some bright spark would have said, oh, look, we'll save... The reading into this case will be a complete nightmare. We should continue to use Mr. X. Or Mr. X will have said, I'm really embarrassed about this. I'll do it for a cut fee. Whatever it was a very strange forensic decision that was made, and it ended up extraordinarily badly. There's only a couple of things that I want to talk to you about from this decision. There's a quote. Any advocate or litigator dealing with an expert will use the internet to see their track record, to see whether they've given evidence before, and if so, how they fared. I read that and thought, oh shit, I haven't done that with one of my experts. Then promptly did it. Yeah, okay. But it is very much a comme ci, comme ça moment when I did it. I then rang my solicitors and said, by the way, you did internet check him, didn't you? So, that's a sort of a nice barrister tactic straight away. Make sure it's somebody else's fault. Tomorrow I'll notify my insurer. It's actually really sensible. I genuinely don't always do it. I always should do it. So should you. Bailey, Ostley, Canley, you'll find it. LexisNexis and Westlaw. If you type in the name of your expert, every now and again, every now and again you can put your own name in inverted commas and see what comes up. You remember how rotten you were back in 2011. But the reality is that it is an exceptionally good piece of advice. But that's not the real point of this. That's not the real fun with this case. This is a tale of two cities. There is the KPMG expert, tick, and the Grant Thornton expert, cross. Mr. Thompson from Grant Thornton and Mrs. Barker from KPMG. Mrs. Barker from KPMG came out a whole lot better than poor old Mr. Thompson did. What's useful from this case, other than just walking you through why it's fun, giving you some really good quotes? What's useful about this case is there was a line of attack made on Mrs. Barker because she worked for KPMG. And the line of attack was, look, if you look at Mrs. Barker gave expert evidence on quantum for the defendant. One of the lines of costs that the defendant is claiming is a huge sum of money for KPMG. Therefore, Mrs. Barker is not sufficiently independent because although it was not Mrs. Barker who was retained, Mrs. Barker was only ever retained to do the work on the quantum side of things. KPMG was into this case for a shitload. And therefore, Mrs. Barker had a vested interest in saying things that supported KPMG. It's very helpful for all of us to know now that Chinese walls work and that judicially Chinese walls work. Mrs. Barker had been expecting the line of attack and was able to show in an extraordinarily elegant way all of the steps that were put in place to ensure that there was a rock-solid Chinese wall between her and between the part of KPMG Same office, admittedly, the part of KPMG that had provided advice that had been the subject of the liability side of the case. And it literally required her to say where she was physically situated, the way she managed her dealings with the other people, and the extent to which she had access to databases that they had access to, and the extent to which her team had access. It was almost a 4-point plan for how to successfully manage a Chinese wall. I always get very nervous when I'm allowed behind the scenes at law firms and I see signs on doors saying, Project X, Project Y people do not enter. Now, it's a very standard, I know where the advice comes from. It comes from an American expert who believes this is the way to manage Chinese walls. If you want to know a bulletproof way of managing a Chinese wall in an Australian or UK context, then frankly, this is a great way of finding out. Merrill's case. It'll show you how to do it. It'll show you how it should be done in a way that will survive forensic inquiry. The judge got to the point where he actually cut off counsel and said, you need to understand this is not a productive line of inquiry. And that's the magic. As soon as you hear those words, you know that you're completely safe. The judge explicitly recognised that we live in a world full of KPMGs, and we live in a world, I'm doing a case at the moment where I have KPMG legal reviewing vast amounts of documents, and it is vast amount of documents in a case where an audit division has also done work on the case. It falls straight into the Merrill category. There are rigid Chinese walls put in place at the large firms these days. They know how to do it, they do it well, and we need never be concerned about it really anymore. And more importantly, from an advocate's perspective, don't think there's cheap points to be had in a courtroom anymore, because they just aren't. The other thing that I liked about this case was, I like Chinese wall. I like this. Mr. Thompson has been the subject of judicial criticism before. This is a link into the internet point. The judge regarded it as fair game for counsel to cross-examine Mr. Thompson based upon adverse findings that had been made against him in a previous court. Now, it's something I tried to do a couple of years ago and didn't get away with, but in the future, I will use this case as support for the premise that in fact I should be allowed to put adverse criticisms made of an expert in a previous case to them, as a way of quite legitimately testing their methods and testing their expertise. I think that's all I need to take for you out of this case. Actually, one last thing on that one. It's why Mrs. Thompson is a good expert. Yeah. Here's why Mrs. Thompson was a good expert. Her approach was fair, balanced and independent. She simply made assumptions that both the liquidation of MMT and the liquidation of XYZ were caused by repudiation, and expressly made those assumptions clear in her report. She did not take a position on disputed matters of fact. It's as good a summary of what you need from a good expert as I've seen. Balanced, independent, more so than the contrary expert, made assumptions based upon what she had been told by her instructing solicitors, and she expressly set out those assumptions in her report in a clear and concise manner. She did not take on a position on disputed elements of fact and disputed areas of fact. She stuck to the absolute fundamentals. Why do I bring up Griff Murphy and Gundawan and 2017 Ontario Court of Appeal? Look, Canada's dicey. Ironically, parts of the US are safer for us to rely on than Canada, because Canada has a two-phase step. The Canadian Supreme Court has adopted a two-phase step on expert evidence. A two-phase test for expert evidence that we do not have in Australia. So the only thing that is useful out of Canada effectively is obiter. This is actually extraordinarily useful obiter. The law regarding expert evidence has evolved considerably over the last 20 years. Gone are the days when an expert served as a hired gun or advocate for the party that retained her. Today, expert witnesses are required to be independent, and their function is to provide the trier of fact with expert opinion evidence that is fair, objective, and non-partisan. It's very useful because this is what we should be saying in Australia today as a result of the reforms that were issued 2 or 3 years ago. This is what we should be saying. We should be saying that gone are the days when an expert served as a hired gun or advocate for the party that retained her. We're not there yet. We're trying to get to that point, but we're not there. This is as good an aspirational statement of what an expert witness is actually meant to be as I've seen. Then, the role of the trial judge in relation to expert witnesses also evolved. Appellate courts have repeatedly instructed trial judges they serve as gatekeepers when it comes to the admissibility. They're required to carefully scrutinise an expert's training and professional experience. Along with the necessity of their testimony in assisting the trier of fact, the expert is qualified to give evidence in our courts. This gatekeeper role is especially important in cases such as this one, where there is a jury who may inappropriately defer to the expert's opinion rather than evaluate the expert evidence on their own. What's our job as advocates? Our job as advocates is to encourage the judge to act as a gatekeeper in a way that effectively does the best by our own clients. The judges are gatekeepers in their own right, and provided we have at our disposal the relevant authorities, the knowledge of the relevant procedures, and the reasons why an expert should be called into line, or the reasons why an expert should be constrained, or alternatively not allowed to give evidence altogether, then we are in a perfect position to assist the judge to act as a gatekeeper. Next time round, we'll start heading into the territory of US, but that's it for today. Thank you very much.